I'm not even sure if it's the right time to ask this question, but since we're moving to another trust subject, and you mentioned that these are relatively new, and a lot of times I'll run into doctors, and typically they'll put their assets in their wife's name, and they'll say, well, this will kind of protect me. So I could think of reasons on my own, but I was just wondering if there's a collective way that we could, some really good bullet points as far as why would you use one of these trusts as opposed to just shifting the assets into your spouse's name if you're in a high liability profession.
Well,
divorce.
Like a selling, well, I know divorce, yeah,
but
I mean, if I had a good list of 20 good reasons, I mean, maybe it's more of a marketing question than a legal one, but.
Well, for me, that's easy, because I meet with a lot of doctors, and in California, of course, we have community property too, but even if it's in the wife's name as separate property, my position would be, I would just explain, somehow or another, the wife could also be involved in the litigation. She needs the additional protection, and she should set up the asset protection trust herself, even if the assets are in her name. And I don't have any trouble selling that, because I just say, this is an extra level of protection, it's worth it. And the reason it's worth it is it's going to create more barriers. There's all sorts of cases where the wife has been sued with the husband, they'll argue that some of those assets are really his, that he has some interest in them, and that she should have her own asset protection trust. Okay, we've got to move on. Is the protector a fiduciary? I think the answer is we're not sure. The likelihood is that the protector will be held to be a fiduciary.
You want to show me how to hold this, Jeff? Everyone's picking on you. I like it.
I think this is an old joke about my challenge technologically. So I think we ought to just from now on drop it.
Jeff, one last question. You had a question about is the trust protector the fiduciary? I know we've got an option in the system to say yes or no. And I'd like to get other people's input on in those circumstances in which the client has finally thrown up their hands and said, I don't have anybody else, lawyer, you've got to be the trust protector. Do you select fiduciary or non-fiduciary? Where I personally have come down is that if I'm going to select non-fiduciary, then I've got to send the client out to get independent counsel about that decision.
Well, I haven't gone that far, because I've got to be practical, and frankly, I want to close the deal, and I want to have the client finish the thing off, and so I just tell the client we check the non-fiduciary, and if the client has trouble finding somebody, we just keep on hitting them and telling them it's not going to work until you have. And ultimately, they come up with somebody. That's what I do. I think as attorneys, we try to do the best job we can. We try to be as practical as possible. But at the same time, we've got to make a living, and we've got to be able to function and close a deal and give the client what they really need. And so we have to somehow or another close the deal, and my experience is if you did that, Dick, I think you'd get situations where with clients that they get frustrated, and then the additional expense of having somebody else be the attorney and bringing in, I just don't think it'd work.